All right. Well, welcome to week 6. We're making it all the way through here for the class. As we discussed, we will be just going over chapters 7 and 8 tonight. Chapter 7 is on management liability, while chapter 8 we're going to be talking about human resource liability or human capital aspects of it. As you'll probably notice, chapter 7 was fairly thin. I think about maybe 17 pages at the most, and then we have a little bit longer chapter for chapter 8. For those looking for the question and answers for chapter 7, as I indicated in the email, the instructor's guide actually didn't have a lot of information to be able to really pass on that would be useful from a Q&A standpoint. And then even chapter 8 was fairly thin of what they had in there. When we go over chapter 8, one of the challenges, at least that I have in teaching on the human resource aspect, is that it's kind of what I do every day, and to a certain extent, I might assume a little bit too much of knowledge or expectations of what people's background might be a little bit on that. But as we go through, I think I'll hopefully be able to provide good examples to kind of alleviate some of the fear. And I think most of the part, it's fairly straightforward. When we talk about safety, I think most people realize, ergonomics and the role that ergonomics plays, or, slip prevention and things like that as we go through. So let's head right into chapter 7. So again, it's kind of light, and even the summary was light in the back of the book. But tonight, for chapter 7 on management liability, we're going to describe the liability loss exposures of a corporation's directors and officers with specific reference to the responsibilities and duties and the types of suits that they may be made against them. Describe the major types of claims associated with employment practices liability, or EPPL, what it's more commonly known as a loss exposure. And describe the legal foundations for fiduciary liability loss exposures. And we'll talk a little bit more about ERISA, Employee Retirement Income Security Act. And obviously, since they mentioned ERISA more specifically, that would be the one that I would probably focus on a little bit more. When we talk about directors and officers liability, really, we've heard you probably throughout the book, it talks about D&O. And directors and officers, insurance coverage, that's something that most boards or nonprofits should probably have some type of insurance policy with it, because it gives peace of mind, as the book kind of talks about, is that if someone's going to give up their time and then there's the risk that they can be sued individually, well, why in the world would I ever even want to serve on a board if there's not going to be some protection for me? And then on the same point, I would say, even like Little League boards or things like that, or we have a road association where I live, and certainly those boards can be sued, and the board members individually can be sued as part of that. So as far as volunteer or paid participation on a board can expose individuals to being sued, as we kind of mentioned, whether it's Boy Scouts or something like that. In order to protect board members, risk managers must understand the role of directors and the types of suits they may be exposed to. And when we talk about, the risk control aspect is the key aspect or management of risk exposure. What we're looking at is, you can transfer. You might be able to transfer the indemnify, or be able to pay for claims. But the reality is, it's what you do it's your practices. It's how you operate, and having good policies and procedures is really what's going to protect for directors and liability coverage. So you can buy, and again, if you're a director or officer, as it talked about, when you indemnify, all that means is you're going to get reimbursed. Typically, you're still going to have to maybe front the money in some cases to be able to defend yourself, but it depends on the organization, what they're able to, or how they would certainly work on that. So when we talk about corporations, the role of directors, officers, so for those obviously in a university setting or public entity, for our purposes, we have the regents for the University of California would be our board of directors. And to a certain extent, even though it's not a for-profit aspect, there's certainly opportunities, from a research standpoint, that is competitive with other universities. And so a lot of these things that you're seeing here, you can probably kind of, you should be able to make connections between a corporate standpoint and then also from a public entity or nonprofit standpoint. So typically, corporations, by being a corporation, are owned by stockholders, but they're controlled by the board of directors. And for those that own stock, typically you're getting some proxy vote, which is 1/10 of a vote or percentage, and because you're not Warren Buffett that owns basically 50% of the company, your vote may not matter as much. But essentially, the stockholders, they participate and they elect the board of directors as nominated by a committee to basically run to provide direction, strategic direction to the corporation. And so as directors, they're elected by the stockholders. They're going to establish corporate policy. They'll also provide oversight on the financial decisions. A lot of times from an auditing standpoint, there'll be an audit committee. There'll be several other strategic planning committee that they might be part of. They'll also make major business and financial decisions. So typically when it comes to a merger acquisition, the board of directors is going to be the body that's going to be making that decision to move forward. Obviously, the CEO, as an officer of the company, will be probably making that recommendation, but they can't make that unilaterally. And that is part of usually the bylaws that the stockholders give, the ability or authority to the board to be able to make those type of decisions. And then typically on stockholders, that they're not on certain types of things. They may there might be issues that they'll have to bring before the stockholders for a vote. But typically those are it's mainly the elections portion, or maybe if it's more of a philosophical type of decision that maybe a stockholder type group might make the decision. The directors also appoint the corporation's executive officers to manage the daily operations. And those executive officers can be the CFO, CEO, COO. It's pretty much a C-suite. And those typically are, really the only employees that the board really has direction over. As a school board member, the only real employee that I have a hiring authority over is the superintendent. The superintendent, that's what we hire them for, is to manage the operations, and the superintendent can then hire their staff, and they're the ones doing, as far as the teachers, things. They'll bring recommendations maybe for termination that would have to go to the board. But ultimately, the one person that we give direction to is the superintendent. And that would be the same thing as the board of directors. Typically, they're not going to tell the mailroom person what to do. Again, their roles can be much more of a strategic nature of how they operate, and then the officers are typically going to be making more of the operational decisions. When we look at other entities, public entities, nonprofits, trusts, limited liability companies, they pretty much all have similar duties and exposures that can be part of that. On the book, it has the major responsibilities and duties of directors and officers. And we've kind of discussed some of these real briefly, but the major responsibilities, obviously we talked about, establish the corporation's basic goals and broad policies, elect or appoint corporate officers, safeguard and approve change of the corporate assets, financial matters, delegating special powers to others to sign contracts, open bank accounts, maintain, revise, and enforce the corporate charter and bylaws, and then perpetuating a competent board by conducting regular elections and filling interim vacancies with qualified persons. And the last one is the one that the book talks about as the biggest focus, is fulfilling their fiduciary duties to the corporation and stockholders. And that really is ultimately what a board member, they're going to be held accountable for the most. And the fiduciary duties, when you look at it from a D&O perspective, but fiduciary duty is the duty to act in the best interest of another. In other words, you can't look at your own self-interest. Is kind of the opposite way of doing it, is that when, as a fiduciary, you have to look out for others, and even though you may gain by a certain decision, it's when you start looking at how you can gain that you start getting in trouble. I serve on a couple other boards, Laboratory Safety Institute as well, and it's a small, very, very small organization, maybe only 3 employees, but the board really takes on a little bit more of those roles. And one of the questions, being a risk manager, started asking, well, what's our D&O coverage? Do we have it? And the question becomes, well, what's our liability if someone's doing instruction and something goes wrong and they challenge the organization, the bad advice or consulting practice that maybe someone had performed. So that's a piece of it. The other thing is, I'll just bring up an example with the Joint Powers Insurance Authority. My former employer, Bickmore, manages a great number of pools in California, public entity pools. And one of the pools they had was a private sector pool that's no longer, actually I can mention it now, it's public, it's AdComp, which was an auto dealer's workers' comp pool. And one of the things that the board ended up getting in trouble for eventually is that they started putting, they wanted to make it more of a profit-oriented instead of a nonprofit, trying to figure out ways that they could, kind of get into the insurance business and saw that as another revenue generator. Well, as that started happening, and that board pretty much was removed. But what also happened is that an obligation of the underwriter, the broker in this case, actually had to disclose, because the state insurance commissioner had basically gave a cease and desist order on their practices, and whether they're going to continue to do that. And so he had an obligation as the broker to report that to the underwriters. Well, again, that's his responsibility from a, he could lose his license. And ultimately the board members didn't like that. But the insurance company did end up writing the policy, but they had a specific exclusion of this type of particular event would not be covered, the thing that they're trying to do. So it really sets in motion the whole fiduciary responsibility of what board members really do have as part of that. This is actually from the old book that I used from the prior book that I think makes things a little more succinct in the corporate duties from common law for corporate directors. And so these are the four that if there's going to, actually, if I remember correctly, there will be a question dealing with what type of duty is such and such. And so the first one is duty of care, which is the exercise good faith and reasonable care in supervising corporate activities. The duty of loyalty, which is to place the corporation's interests above own personal interests in financial or other gain. And from my past experience with another organization, for the first time ever, I saw someone actually being sued for failure of duty of loyalty. And what the situation was is that it was one of the owners of this company that eventually was basically looking to form his own company or break off, and was actually looking to siphon off clients of the current company. So there's actually a duty of loyalty to, because they're still a shareholder in that company, to place corporations' interests above their own interests. And so there's actually a suit filed specifically on the duty of loyalty claim. So that's, again, where the common law aspect would be. The duty of disclosure, to disclose material facts to all who have a right to know such facts would not otherwise be able to obtain them. And that kind of goes back to the AdComp example, that as a board, if they have a financial interest in something or conflict of interest, that they need to disclose that. And actually that kind of goes to, as a school board member, and for those that work in the public sector, most recognize the Form 700, which is basically a conflict of interest form where we need to disclose any gifts that are provided to us, where our dollars come from, our salary, our spouse's money as well. So basically, if someone, because if we don't disclose that and we make decisions, then someone can basically say that we're violating the law essentially and had the conflict of interest to possibly benefit from that. Lastly, the duty of obedience is to perform duties according to statutes and terms of the corporate charter. So, on the obedience side, obviously you need to follow the law. There's a responsibility as a board member to do that, but then also to follow the charter of, or the bylaws of the organization for which you're a board member of. It becomes part of it. So to go a little bit more detail, specifically, probably the duty of care is probably the most common and the most prevalent that most people rely upon is, and there's certain standards to be able to act in the capacity of the duty of care. And so one of those is to act in good faith and in a manner they reasonably believe to be in the corporation's best interest. So again, I think that's somewhat of a no-brainer there. And then also discharge their responsibilities with informed judgment and a degree of care that a person in a similar such position would believe to be reasonable under similar circumstances. And if you notice, it's kind of back to the prudent person or reasonable care aspect. When we talk about duty of care, the idea is, what would again, a person that if I was on this board, what would we expect that person to be doing? And so part of the duty of care would be reviewing, actually reading the minutes before you vote on, reading the material if you're on a board before major decisions are being made. And if I've seen cases where board members don't even open up a board packet until they get to the meeting, and I mean that could be someone can make a charge of not meeting the duty of care standards because they're not taking the time that would be expected to serve in that role. And that's where they might even be called upon to basically step aside. And then the other part of that is what they call the business judgment rule. And it's basically a legal rule that provides that a director will not be personally liable for a decision involving business judgment, providing the director made an informed decision and acted in good faith. And so the idea is that if I'm on, so while someone might be sued, let's say they sue an organization and the board and the members of the board, or maybe they just pick out one. If I can basically demonstrate that, I've good faith effort in my role, I've attended the meetings, I've reviewed the information, and making decisions that are, that are not in my own best interest, but in the interest of the organization. Basically, the courts will most likely rule that I'm not personally liable for any of the actions. That maybe the corporation might still be liable, but at least myself individually may not be liable for that. When we talk about suits that can be made against the directors and officers, there's the two types of suits, are derivative suits and non-derivative. And the idea that you remember is a derivative suit is essentially it's an extension of the corporation. So it's a lawsuit brought by one or more shareholders in the name of the corporation. So, and if there are damages go directly to the corporation, not the shareholders. And then, if anything, the plaintiff would only be awarded expenses incurred for legal fees, things like that. But and again, what they must be able to prove is that the defendants violated the business judgment rule, that they weren't acting in the best interest of the organization, they weren't, attending meetings, they weren't doing what they should have been doing. I don't know how often you probably see those suits. I think more common we do see the non-derivative suits, which are suits not brought in the name of shareholders. In this case, it might be customers, employees, creditors, or government entities. But it could be a shareholder could file suit, as we'll talk about in a moment. Stockholders can bring non-derivative suits in their own name as opposed to suing in corporation's name. And so there is actually a class action lawsuit against some of the decisions, and I can't remember which company. Actually, I think it was some of the mortgage companies in which they individual shareholders sued and had a class action, and essentially saying that they lost value because of the decisions that the board made. And so it wasn't the basis of the corporation, but them individually that they brought the suit. And in these type of suits, the plaintiff must show that an injury or injustice resulted from wrongful acts or omissions of directors and officers. So again, there must be some type of injury. So in this case, where they might sue is, well, they lost income, the injury is they lost revenue, or in this case, if there's injustice, they would have to show that somehow they were denied some type of rights. And that injustice could be because of damage to property of what the company did or something like that if they contaminated the property nearby. Some examples that are provided, providing false or inadequate disclosure in connection with stock issuance, making or permitting false entries in corporate books and records, preparing and signing false documents with regulatory authorities. And so that kind of goes to Sarbanes-Oxley. So you can kind of see where some of these suits become more common now. WorldCom and Enron and some of those other things. Essentially, what it was found was that Arthur Andersen was the accounting company for Enron, I believe, and their auditors were basically signing off on false documents. Now, whether and I think back then it's been a while, but the shredding of all the documents at what point? So obviously they're there's something going on that shouldn't have been, and you know, I think Arthur Anderson's pretty much gone now. Failing to correct inaccurate statements within a prospectus issued by the corporation. Failing to review annual financial statements and monitor corporate affairs, and as well as missing an opportunity for expansion, acquisition, or sale of the corporation. And that can be one where, again, there's an opportunity to certainly be able to, you know, should the company sell, or how the sale is conducted, that can also be an attempt to go after directors and officers. As mentioned a little earlier, class actions are probably more common, where you're going to see not individual people suing, but it'll probably be a class of people. So a class action, as most people know, is a lawsuit, which one person or a small group of people represent the interest of an entire class of people in litigation. For directors and officers claims, typically based on wrongful acts related to securities. And so some of the common allegations are corporate or public statements, reports containing material misrepresentation or omissions, alleged misrepresentations or omissions artificially inflate the stock price. So we've heard stories about how people kind of anonymously posted something on a social media site, and all of a sudden the stock goes crazy and people buy. Or someone can make a claim against another company and kind of put out bad information about a competitor, and the stock price might go down. And so that could also be an injury, so to speak. And so the other piece of that is, while inflated, insiders sold personal holdings for profit, and following insider sales, stock price dropped sharply. So basically, when we talk about, you know, class actions, it may have to do more with insider trading aspect of someone's benefited, and there wasn't really a fair shake at it. One of the things that happened fairly recently in the last several months, there's discussion of Bloomberg terminals that are in stock exchanges, and that everyone has these terminals, that there's certain clients of Bloomberg that actually get the information about maybe 3 seconds earlier. And the discussion is that fair? Even though it's 3 seconds, the way things work on the stock market, that could be worth millions of dollars, that 3 seconds worth of time. And so that, again, that's one of the issues that's been discussed fairly recently as well. When we talk about indemnification of directors and officers, again, it just indemnification, you know, a lot of people think, oh, that means I'm not going to go to jail, I'm not going to pay anything. It just means that, you know, they can be reimbursed in the event that an individual board member is sued, and again, they would have to prevail. So the idea is that if I, you know, defend myself and I win, then I might be able to recoup the dollars. Now, there's a lot of section in the book there. They talked quite a bit about this, but I think the key points here that probably will be, if anything, on the exam is that some case law basically have not allowed indemnification to what they call ultra vires, I think is the right word, which is an act of a corporation that exceeds its chartered powers. The idea that the charter of the organization is not there to defend the board members, or, you know, they're to conduct business and what the operations of the business are. So by paying this dollars, it's not really in the best interest of the organization, so therefore they shouldn't be paying or indemnify, even in the case where the person basically prevails or, you know, is found innocent. Several states have passed laws granting indemnification to directors and officers, and other states actually require it, that they grant indemnification. For most states, for indemnification to be allowed, the corporation must adopt contractual provisions that set guidelines for reimbursement. In other words, you just can't say, we'll just do it willy-nilly. There's got to be some type of policies in place, you know, either in the bylaws or some type of documentation that really spells out, in the event of a lawsuit, this is how we're going to handle it. Here's what's going to be reimbursed. At what time will it be reimbursed, and those type of things. Again, indemnification is retrospective, and it occurs after a case is concluded. So as it mentions, directors and officers may need advances to cover expenses before settlement concludes. But what they've also found is, like Sarbanes-Oxley prohibits such loans in most cases, so they may not be able to get advances, and depending on the type of organization. If it talks about also agreements to refund may be difficult to enforce. So even if there is somewhat of an agreement, at some point maybe the corporation says, no, we're not going to do it. So that's why the policies are so important. And also the advantage if they determine that, well, though the person was guilty or they were charged and, they found it to be, I don't know if guilty is the wrong word, but found to be at fault, that how are they going to get the money back? The person's going to, now they owe this money, so plus the indemnification charges, how would that actually work? So most people have heard of I mentioned D&O insurance, but only transfers the financial risk. So indemnification, so the D&O coverage will basically say, hey, well, after everything's said and done, this is how much was paid out, and so they'll pay monies back to help pay for the legal fees that were incurred. But again, it may not store the corporation's reputation. And it talks about in here the potential pillars for risk control program liability, and to help protect it, establish independence of the corporation's board of directors, provide opportunities that encourage open, clear, and concise communication among directors and officers, ensure that directors and officers fully understand the organization's operations, corporate charter, bylaws. So this is kind of the risk control aspect of here's how you protect yourself, have good policies in place. Now for the school, as a school board member, one of the things that we have is we have what we call the Brown Act, which basically it's called the open meeting law, and the idea behind that is to encourage open, clear, and concise communication, that all decisions are made in the public domain. They're not made behind closed doors, except for those things that are closed session in nature, and everything has to be posted so the public has an opportunity. So there have been cases where people charge that a school board or another public entity, for California applies to all public entities, government entities, that if they don't properly post and minutes and the agendas, they could be charged with a Brown Act violation. And typically what that might mean is the decision which was voted upon in which this violation occurred may be nullified, or someone could sue the board members, or they can be deemed as collusion of maybe 3 of the board members or something like that can be part of it. So now kind of moving on to the other piece of this, which is the employment practices liability, or EPL loss exposures. I think one of the key elements that, what started, the primary EPL type claims was the Civil Rights Act of 1964, which mentions the first significant law which prohibited discrimination by employers. And so that's when you started really seeing, any type of really employment practices claims. Now, even though there's EPL insurance, it many times will exclude violations of certain laws. So if it's deemed, that the person violated a specific law, the coverage might be void. But there's a lot of situations where there might be, liability that a law doesn't cover, but it can be considered to be discrimination. And part of the challenge is, you want to say, the criminal aspect, or versus civil aspect when we start looking at some of these. So the major types of EPL claims, and when someone makes a claim, it may involve more than one of these, and probably does in most cases. The first one being discrimination, wrongful termination claims. We have sexual harassment claims, retaliation claims, and then there's kind of everything else that falls in there. The laws that affect the EPL type claims, and I would, I wouldn't go too much of knowing exactly, but the certain ones I think would be important are the Civil Rights Act, both the 64 and 91. ADA would also be one that I think would be there. And then typically, I want to say there's typically COBRA and ERISA. The Warren Act we'll talk a little bit about, as part of the FMLA. A lot of these things I think most of us, a lot of times, just from work setting, you get more familiar with when we look at them. But one thing about ADA, since we're not going to go into much more, is that ADA is a little unique. Is that it's, even though it's a it's a federal act, and California has somewhat of our own version of it, but it's enforced by the public. So what that means is the government, in order to enforce, to have people change, people have to file civil lawsuits. And so that's why you kind of see, what some people term shakedowns of private employers, of people saying, well, the bathroom handle's on the wrong side, or those type of things. And so that's where you see more of those type of claims. So Now, there's also discrimination, so that's more of kind of the access issue for the non-employee, but then if you're an employee, there's a certain provisions in there that require that you do make accommodations for persons with disabilities. And also from after a person, let's say it's a work comp claim, in California there's, well, this is going way beyond what will be on the test, but interactive process, that there's got to be, after someone's been determined that, that there's a disability, then HR gets involved, and there basically has to be, as interactive implies, it's really a formal discussion and documentation of what kind of accommodations reasonable accommodations can be made for those employees. So discrimination claims, again, discrimination does not have to be intentional to be unlawful, and a lot of times, and this is kind of where the ignorance part may come in. For those people who just, the way they were brought up, they don't think they're just being discriminatory, but they are. So types of discrimination, which is overt discrimination, intentional, is a specific observable action that discriminates against a person or class of persons. And I think, we can kind of, with gay rights and all that, that would probably be one where there's probably been a lot more overt discrimination that's occurred in the past, and now we have more court cases that are helping, prevent that type of discrimination. There's disparate treatment, which is unfavorable or unfair treatment of someone in comparison to how others are treated. And so it might be that in an office setting, maybe the females get more attention, or it could be maybe it's the younger person versus the older person, and it's more just, one person can claim that they're not being treated the same way as the other employees for whatever reason. And then disparate impact is application of personnel policies to applicants or employees that have effective denying employment or advancement of protected classes. So really the difference between disparate treatment and disparate impact is really disparate treatment is one person kind of, maybe doing that where there's an aspect of it, whereas the disparate impact is it's because more of a policy. And so as indicated in the book, there could, for a while there, I think within fire departments, there's the idea that, well, you didn't have any women because of the policies, of the personnel policies that where they, couldn't maintain or the standards that they had in place, and that there's no way, because the way they're written, that women could possibly be, firefighters. And I think that, there's lots of different examples I think people can think of, whether it's height requirements, those type of things, but the idea is that the standard should apply equally to everyone, and it shouldn't exclude anyone just because of a specific, type of condition. Wrongful termination, it probably accounts for the majority of EPPL claims or cases, and the idea being that obviously when someone's sued because they feel that they were wronged for whatever reason, and usually it's because they felt they're discriminated against, or a person says, look, I did all these things, and all of a sudden I get terminated. It was out of the blue. And so again, most of them there'll be some type of claim of discrimination of why they were terminated. And even though a lot of times you hear the word at will employees, or at will, a lot of states have kind of held that even if you're in an at will state, or you're an at will employee, there's somewhat of a implied contract that there's going to be at least some cause. That, and so typically in order for California to get, to be denied I'm trying to think of the unemployment benefits. So if you're terminated and you apply for unemployment benefits, the only way the employer can then deny those unemployment benefits is to be able to show just cause that you were performing poorly. So in many ways, they may be able to just terminate for any reason, they're still going to end up paying for the employee through unemployment unless they can determine just cause. So that's why many employers still really do that documentation, because they'll pay for it one way or the other. On sexual harassment claims, really emerged after the EEOC defined sexual harassment as unwelcome sexual advances when submission to such conduct is made either explicitly or implicitly a term or condition of employment. And so, again, the idea, when we talk about, it was more specifically sexual harassment, but now, as we talk about, the book still talks about sexual harassment, but just harassment in general. It can be what's considered a hostile work environment due to race, disability, religion. So, but obviously, sexual harassment is probably the one that's most defined, that most people, see. We see that now with Bob Filner in San Diego. Is that sexual advances? He made them explicitly in some cases. It sounds like. It wasn't necessarily a term of employment, but there's, it's unwelcome, so that was really the first part of it. So now some claims can be based upon a hostile work environment, which is when an employee is subject to sexual harassment that is so severe or pervasive that alters the working conditions. And I would say that's probably more accurate what happened in San Diego, is that, how can, and I think it's the city spokesperson was the one that originally filed the claim, saying that she cannot work in those working conditions because essentially it was so pervasive that it, in the hostile work environment, in order to prove that, employee is a member of a protected class. So, based on race, sex, those type of things. The employee was subjected to unwelcome harassment based on the protected characteristic. Being female would be that characteristic in this case, or at least the opposite sex, because it can happen both ways. The harassment affected a term or condition of employment. And the employee knew or should have known about the harassment and failed to take prompt remedial action. And so the idea is at some point it was reported, no one said anything, and it just kind of continued because, because no action was taken. And that's usually probably, at least, more things that aren't on the test. What I've seen is when, HR departments, they take these claims very seriously, they document. It really, they're doing the documentation, obviously because they want to get to the bottom of it, but it also, in the event that the person still decides to file a claim, they're going to be able to show that they've took all reasonable steps. They, they moved the employee, they did something to try to correct the condition. And that's part of it is, how can, because the defendant's going to have to show, or the plaintiff's going to have to show that they knew about it, didn't do anything about it, and that's really why the documentation is important. As I mentioned before, hostile work environment can now be claimed for a lot of different areas. So, religion. What I can say that, when I was working for Raley's many years ago, one of the I was throwing freight on a night crew, and when you're 10:30, or 1 o'clock in the morning, doing work and people have music on, we did have a person that claimed that it was a hostile work environment because of the music that was being played. He was Christian and felt that that the music being played, created a hostile work environment. And so essentially there, part of that, and it's like, well, how do you satisfy different people? What station is going to be on? It's hard enough with kids in the car to decide a station. Now we have employees, and so basically, just like parents do, we say, okay, we're going to shut the radio off. No one's going to listen to the radio at all. And that's essentially how that that was remedied, and so that becomes a challenge. Once the employer is notified of the situation, a complaint was made, there has to be some type of action taken on that. And also the other part is that after that happens, and we'll kind of go to retaliation here, and you can't retaliate against that employee because then that just even presents more of a claim that they might have in there. So how do you control employment practices, liability, loss exposures? Reduce the frequency and severity of EPPL claims. Establish hiring practices that comply with standards set forth by private law. Make sure employee handbooks are clearly state company policies and procedures. Provide all employees a formal policy regarding sexual harassment. Make sure everyone should have training, document the training. So even while there wasn't a law that everyone has to take sexual harassment training, most employers were already doing it because it really helped protect them in that regard. Permanently post and distribute all EEOC documents as well as state and local compliance documents. Conduct, and this is actually a big one, conduct employee performance reviews at least annually. And as much as people may kind of go, well, what's the point? It's, if people view it as a raise, it's also because if performance does drop off, that's your documentation to say, look, we noted this behavior, and that's why performance reviews are actually so important, and why a lot of companies unfortunately fail to do those. Follow carefully documented termination procedure, exercise special care when handling termination, conduct exit interviews and document them, and investigate all allegations of harassment and discrimination. Now, if you look at this and you go, this is common sense, well, yeah, I think, for those that, UC or other large employers, they really try to follow these things because that's the standard of care. This is kind of going back to what a prudent person or what would a reasonable person expect. Well, this is the standard of care as an employer, what's expected to be done. And if you're not doing these things, or if there's ambiguity in your policies, basically an organization is opening itself up to have an EPL type of claim. So retaliation claims are usually brought by employees who filed a work comp claim, testified against the employer, or become a whistleblower. And so there's specific protections for whistleblower. UC, we actually have a whistleblower hotline for people to anonymously report those things. You see the claims, obviously now, Snowden's claiming, as a whistleblower. There's been other people that have testified that have been whistleblowers. And the things you sometimes see is that, well, the person got fired after, they whistleblew, and that basically they can get compensated for that if they can prove it was directly related to it. Filed work comp claims, I mean, there are some organizations, unfortunately, where I've seen where someone files a claim and we see that, all of a sudden they get terminated, or the hours, something happens. So that happens as well. Or let's say there was a court case and they didn't the employee didn't testify the way the, way the employer wanted, and that could also be subject to retaliation. The other types of EPL claims you might see, EPL claims that don't fall with the context of the ones we've mentioned about wrongful termination, sexual harassment. One of those would be the WARN Act, which was passed in 1988, which stands for the Worker Adjustment and Retraining Notification Act. And the idea behind that was to help mitigate mass layoffs. If I'm correct, if you lay off more than 50 employees, you must provide certain notice and compensation. You have to have, so many 60 days notice, and you have to provide so much of a severance package. Now, at one point when Raley's was doing layoffs, the way they, so they didn't have to do the WARN Act is you lay off 49 people. But the thing is you can't then lay off more people a little bit later. You have within a certain time period, because there's how you can fudge the rules. You have to kind of within a certain time frame, you can only have so many layoffs based upon that. The other big thing where we see more types of claims from employer practices is either time reporting or mandatory breaks, and you see tons of class action lawsuits. I know Sutter Hospitals, I believe, a while back, this became an issue where they're enforcing now, where people weren't taking their breaks. So even if the employee wants to work through their break or wants to work through their lunch, they can't because it's a violation of labor law with break time, mandatory break time. And so because you can't, and part of it is because if other people do it, then the expectation is, well, the person that doesn't want to do it's going to be looked differently, and then so that's kind of where that comes into play, is that it becomes kind of the culture. Walmart, I know, has been charged with this as well, that in the past, but a lot of companies, this has become a big issue of the time reporting, how they're compensated, and things like that. And so then we talked about fiduciary liability. So we've gone through the different types of liability. Now, fiduciary liability loss exposures that rise mainly out of employee benefit plans. So again, just keep in mind when we talk about fiduciary liability, now we're talking really about benefit plans or health plans. And so a fiduciary in this case is usually a plan official, or fiduciaries would be plan officials, and it's a claim made against the plan for breach of fiduciary duties. And claims can be made based upon investment practices or unfunded liabilities. So the idea is that you have a pension that your money's in and they made some bad investment choices, or if you can prove that those investment choices weren't sound business practice, or they made them in their own interest rather than the interest of another, which is the duty of fiduciary duty is to make it and decisions on the basis of another. That becomes part of it. So the acts and topics that are related to fiduciary responsibilities, the Employee Retirement Income Security Act, or ERISA, and that was mainly that was meant to address the underfunding of benefit plans for again on the private sector, and this is kind of something with ERISA. Private sector was always at one point had to show these benefit plans if they're underfunded as liabilities for future liabilities. It wasn't until fairly recently that public sector now is under GASB 45, Government Accounting Standards, now also has to basically account for future liabilities instead of a pay-as-you-go, so they make sure that they do have the proper money. And then the other part, Health Insurance Portability and Accountability Act, or HIPAA, which I think we're all familiar. When we go to the doctor, they have us sign the HIPAA form that basically says, it's a disclosure of what they can share. And it sets standards for health insurance portability, limits exclusions for pre-existing conditions, prohibits discrimination, enrollment, and premiums based upon health-related factors. And then the other part of this is that there's certain duties and liabilities of plan fiduciaries that they're required to do, and that's on the next slide here. So there's specific duties. You'll notice loyalty, same kind of the duty of loyalty. Fiduciaries' actions must be solely in the best interest of the plan and all of its participants and beneficiaries. Prudence, must carry out his or her duties with care, skill, and prudence. Diversification, must ensure that the plan's investments are sufficiently diversified to minimize the risk of large losses. So the idea is if you're the fiduciary, the one that's managing the benefit, are you interviewing the investment manager? Are you making sure they're doing their thing? Are you making sure that the portfolio is diversified? If you're not doing that, that can be an ERISA lawsuit. And then finally, adherence is a fiduciary must act according to the plan documents and applicable law. If the plan document is not in compliance with the law, the fiduciary must follow the law and bring the plan document into compliance. So as laws change, the fiduciary needs to make sure that those are part of it. So that's management liability in about 45 minutes here. All right, so Chapter 8, Human Resource Risk. You'll find is this will actually go fairly quickly when we start talking about human resource risk. So part of the objectives, describe the human resource potential of an organization and the factors that affect it. Describe the following personnel causes of loss. So work-related injuries and illness, which I think most people are aware of. That and we want to make sure people are safe at work. Retirement and resignation can be a risk from a human resource standpoint. And then finally, work-related violence is also really more recognized as a human resource risk. Explain how the following methods help risk managers assess personnel loss exposures. So we'll go through, the questionnaires, loss histories. You'll notice that this list is the same way you would address other types of risk. Is you're going to be looking at risk assessments, loss histories, flow charts. So this would be how you'd want to assess risk in general for other types of liabilities. Explain how the following risk control technique can be used to mitigate losses arising from work-related injuries and illness. And so we'll talk a little bit more about avoidance, loss prevention, loss reduction, separation, and duplication. And again, what you'll notice is these 4 ways of doing it are the same ways you avoid other types of risks: avoidance, loss prevention, loss reduction. If we're looking at operational risk from parts, or those type of things from operational risk, we're going to look at those aspects. Explain how to mitigate losses arising from work-related violence, and then we're going to do the case study, talk a little bit more about that at the bottom. So when we talk about human resource potential, it's the definition they provide. It's an organization's human resource potential is the collective capacity of an organization to produce goods or services of value by using existing skills and knowledge or the skills and knowledge developed in the future. So essentially the idea is it's people. Human resource potential is the capacity of how you're using people, what you're what the potential of your personnel may be with additional training or with additional skills, and what they essentially provide as goods and services to the company to be able to make a profit. So when everyone looks at, well, why is it called human resource management? Well, because you really are, it's human resource management's the benefit plan. It's, because that helps retain people. It's make sure people don't get injured. It's also identifying good people to hire as part of that. So part of the factors that affect human resource potential: health and education of the general population. So as a risk manager, you want to make sure that there's a vested interest to make sure that where you're located is near good schools, that it has a population that's able to perform the type of work that you're looking to do. So if you're, and this is probably the challenge if you think about, okay, Detroit, with the auto workers. So most of the workers that obviously have lost jobs, so there's certainly capacity for people to do work, but for the most part, the work they were doing was more in its manufacturing sector. It wasn't white collar, it's blue collar work. So if you're trying to locate a company that's more high skilled or technical skills, you may not have a good hiring pool. The other aspect talks about, with good schools. Well, it's also good health. There might be, because, was it the most recent, the most obese state, Mississippi, and another one. So there's the aspect of, okay, are people in good health, or is the air quality, it might even be considered air quality. I mean, there's all those things. So so when we talk about human resource potential, we're also looking at the surroundings. It's not just the people we hire in the very beginning, because we need to have a good pool to hire from in the first place. When we look at proper personnel selection procedures, hiring the right person the first time, making sure they pass the probationary period. One of the challenges, again, from a human resource potential, is that when we look at people that are terminated or leave after 60 days, there's a huge cost to hire a person to get them all trained, and then they leave, then or they went to a competitor. You don't want to become the training ground for another employer in some cases. That could be the case. So personnel selection procedures are part of that. Preservation of employees' existing productive capabilities, essentially, meaning we don't want them to get hurt, and so that's also why you see such a huge push on wellness, because wellness and benefits packages, it has to deal with, we want to keep the productive capabilities. We don't want them to leave. So not only do we want to make sure they're not hurt at work, but we also want to make sure they're healthy and don't get hurt at home, because whether disabled at work or at home, if they can't perform the work, we've lost that human resource potential. And so that's why you see more things, even like, well, UC's gone, this is a good example, to go to smoke and tobacco-free campuses. Part of it is obviously on the campuses, but you also see a lot more healthcare plans that are giving more incentives for people if they quit smoking. Rehabilitation of injured or ill employees. So if we do have them injured, how do we rehabilitate them? We want to return employees to productive capacity. So that's part of the human resource potential, what affects it. And the retention of productive employees. And so that's where good wages, benefits, and then the idea that resignation or retirement of productive employee is a risk to an organization. So if people, when we talk about resignation, that means people leave to go to the competitor, they form their own company, that can be part of it as well. And as well as retirement, we need, and that's where succession planning, and we'll talk more about that, really comes into play with some of the examples. So the types of personnel losses that typically we deal with are work-related injuries and illnesses, retirement, resignation, and work-related violence. And so we're going to go through a couple of these. So injury versus illness. So if the question, there might be something that kind of comes up, and we'll, again, talk a little more detail, but injuries are usually acute, which is caused by external physical force that result in laceration and fracture. So the idea is that something happened instantaneously. Now, a lot of times when people say, their back was injured, that all of a sudden they have a back injury from lifting, it's typically considered an injury because you really can't determine at what point was, because it was acute at that point in time. in many cases that some people might consider it an illness, and because it probably was going bad, and then all of a sudden there's that one final lift that's that really broke the back there. An illness is usually developed slowly over time and can be due to exposure to substances over time or repeated use of body parts. So the idea of, okay, an illness, asbestosis, radiation doses, ergonomic, musculoskeletal, carpal tunnel, repetitive motion. So most people don't realize, but repetitive, those are considered illnesses because they're cumulative. They appeared over a period of time. Noise exposure is considered to be an illness because, again, your hearing loss is over a period of time. And what you'll see is, for those familiar with OSHA logs or OSHA 300 forms, you actually have to document whether an injury was an injury or an illness, and actually specifies what an illness is for those particular issues. Typically, injury, cause of loss, machinery and equipment use. So again, we're talking about acute injuries that something fell on an employee, something like that. Materials handling. When we talk about material handling, we're talking about lifting. So that's more, in some ways, it's body mechanics, that people are having to move material, whether it be using, hand lifting it, or maybe it's using a forklift, those type of things. Other types of losses, vehicle fleet operations. Actually, vehicle fleet is probably the most common cause of death in the workplace, people driving. And so vehicle fleet operations are pretty good exposure. And then finally, the physical conditions of the premises. And so what that means is there's water on the floor. It's housekeeping. People didn't clean up, and they trip on something. So the physical conditions can also cause an injury. One thing that I'm disappointed in the way the book is, it's not in the book, but when, what other cause of injuries, and really probably the most common, is employee behavior. And that's not following safety rules or bypassing safety devices. So we can have all this equipment, but the reason why they got injured on the machinery is because they took off the safety interlock switch, or they took off a guard. And so it's because of that behavior of them trying to do something quicker, be more productive, that in some cases caused injury. So even though it's not in the book, but I just can let that go past without saying that. So on illnesses, cause of loss there. Typically, the illnesses that we're going to see, long-term chemical exposure, noise levels, ergonomic stress, what we commonly refer to as musculoskeletal disorders, MSDs, radiation, temperature extremes can also, so heat-related illness. So that's in California. We do have a heat illness prevention program requirements that require training, and once the temperature, I think it's above 85 degrees, for employees, or once it's projected, you need to have a plan in place to provide shade, water, those type of things for employees. And this was 1 year, I think there's 13 deaths that occurred in the agriculture industry that really prompted the changes in California on this. And then finally, poor air quality can also be that. So when we talk about air quality, people may think of smog. Well, it's also indoor air quality. If filters aren't being properly changed, there might be some aspects where people are breathing in things that shouldn't be breathing. Or in a laboratory, for example, if the fume hoods aren't working properly, the air exchange rates, that's where industrial hygiene really comes into play. And really all these things we're talking about, it really deals with the illness aspects of employee health. The other aspect we need to be concerned about, retirement and resignation. So when an employee retires or resigns, what the organization's losing is the future value that the individual would have provided the organization. So what revenue would that person produce? So if I'm the top seller and I decide to go work for another company, well, now they're getting that productive capacity out of me, not you. Same thing with retirements. At some point, when someone retires that has a certain knowledge, they might be a key personnel to where, I'm trying to think the right term for it, but a rainmaker, so to speak, that people go to that firm because they know this one person, and that's what they're kind of for the name recognition. Well, that person retires, that might affect that, the profitability. Organizations must monitor for increasing employee departures and determine the cause. So problems may be identified with the next interview, or the issue may be with one manager, or be a pervasive throughout the department or the company. So if all of a sudden you start seeing that, people start leaving a particular department, or has higher turnover than normal, then we certainly need to address that. Now, turnover for some organizations, or actually I'll put, food service departments, for example, or dining services. Typically, you're going to have more turnover, at least on a university campus, in some of those positions. Some of that's because it's student workers, and so we kind of expect to see some of that turnover. But if we see one particular department have a little bit more than normal, then that might draw some attention. Now, I put on here an example of TPA headhunting. So about 10 years ago, there was really a shortage of adjusters for work comp, or for third-party administrators that would handle claims. And so what was basically happening is that as a person that was using a TPA, the adjusters seemed like they were changing every 3 to 6 months. And what was because there's such a shortage, and not only of TPAs but of really good TPAs, those that were known to be good were essentially being offered signing bonuses and other types of things to be recruited away, and they just kept on going back and forth, and and that became a challenge. So part of it is all of a sudden you start seeing people leaving. From a business standpoint, what you started seeing was the TPA saying, okay, we're going to offer more money to our employees. We're going to do certain things to retain them, so they won't be attracted to go to the headhunting route. So again, when we talk about human resource potential, what people earn as a salary is important, because if you lose that top adjuster, you may be losing a lot more, because then your clients may say, I'm going to go to that company where he's working now. You got to look for examples where that might happen. The last one on work-related violence. So there's typically two types of what we consider to be work-related violence, or the way they define it in the book. I think, or work-related, not violence, is that when people think of workplace violence, that's what they typically think of, or work-related when we use those terms, because we see it so often with the shootings and things like that. But it also includes kidnap and ransom. So when we talk about workplace violence specifically, it includes any type of violence or threat of violence that occurs in the work environment, including verbal assaults, threats, coercion, and intimidation. So how do we prevent this? First we need to identify jobs that are higher risk. So we know most likely those that are more banks, or convenience store clerks, things like that. A violent workplace may cause employees to be fearful or depressed, resulting in reduced productivity and increased rates of absenteeism, disability, and resignation. Employees who handle money and or deal directly with the public are particularly vulnerable to violence. So those that, in certain public buildings, again, where there's, maybe the neighborhoods aren't the best and things like that. Workplace violence may also cause disability losses, sick days, workers' comp, disability claims, or even lawsuits against the employer. So you might see stress claims. After an act of workplace violence, it's not uncommon to see others either not come to work or claim stress because they feel that they can't come back to work in those situations. And a little bit we'll talk about how do you, what's the risk control aspects to help mitigate some of these. Under kidnap and ransom is loss exposure that organizations are likely to face if they operate in high-risk overseas location. Right, but we're in Mexico lately with what's going on with a lot of the kidnaps in there. And there's actually KNR, so kidnap and ransom. That's what we refer to. But so key personnel are at higher risk for kidnap and ransom. And then the prevention techniques we'll talk more about as well. But unmarked vehicles, locating personnel in safer location, instructing employees on the risks of those areas. But again, when you assess it, what's the possibility? What type of, you want to take a look in your organization, what's the possibility of kidnap and ransom? I'll give an example, and maybe it's kind of work-related violence issues that, but President Udall is very, and I think when he was at University of Texas, something happened because now he has security with him at all times. He is very specific on having a security bodyguard essentially with him as part of that, as part of his work here. And unlike the other security guards, from my understanding, that the one that's assigned to him will, I don't know if to say take the bullet supposedly, but but they're held to a higher level than some of the others, to where they're intended to intervene.
Eric, I have a question. When you're talking about human resource risk, is it a risk, sort of the inability to be able to easily kind of terminate employees? Working for government, you sort of hear, well, it's easier sometimes just to marginalize a particular worker and hire someone else to do that person's job for them than to actually fire that person.
No, I think if you keep in mind that when you think of risk as being able to achieve your objectives, and if you have someone in a position and it's not performing and achieve the objectives, that becomes a risk. And that's where those personnel policies come into place, because if they're not performing, and then if you're not documenting, then you're also opening yourself to an EPPL claim. And so I would say that public organizations, I mean, I've seen a number of organizations that are able to terminate. I think public entities get so scared of having a lawsuit, right, that they kind of do that, that they hire someone else. But the reality is that they just follow the kind of rules and say, okay, let's follow the performance evaluations, let's document and go through that. I mean, even with teachers, I mean, on school board, there's been teachers that have, it's not a 5-year process. But you do have to be diligent on, you have to have a performance plan and all those type of things in place. So yeah, I would consider it a risk. I mean, it's a risk. There's two different types of. There's a risk of terminating and not following proper laws and procedures on the termination, which pose a risk from financially to the organization. Then the other risk is keeping people on that shouldn't be working, that are non-productive, when you can replace or find another person that can be much more productive for the dollars that you're paying for that person. So yeah, I think that'd be appropriate. I mean, not just thinking going to be something probably on the test because it's not on there, but absolutely. I mean, but that's a really good way, and that's kind of the 50,000-foot application level, is when you start thinking, okay, what's the risk to the organization? You can start thinking that way. Go, okay, yeah, and how would we solve that problem? What would we do to get those, to have employees that aren't, really successful, to have them move on, so to speak. So when we assess personnel loss exposures, so these are the methods to assess, and again, what we talked about last time, prior is that, risk assessment questionnaires. These are the same things that we've seen before. So when we talk about risk assessment questionnaire, we might look at injury-specific questionnaires to understand operations and exposures. So a lot of times there's insurance. It's AM Best. I can't remember. I think it's AM Best has a guide that essentially, if you say, I'm working in tree trimming operations, it's going to say, here's the risk, here's the likelihood of hazards, here's the things you most likely would expect. And the idea is it's for insurance underwriters to kind of look and see, okay, what are the exposures of the operations? If I'm operating a car dealership or body shop, the exposures are, we know, to fumes from, paints, that VOCs, volatile organic compounds, to silica possibly. So you can use a questionnaire and say, okay, here's the operations that people are doing that'll help identify that. The other one that's probably the most common is lost histories, which is basically you want to analyze past workplace data. So if you're coming in and you want to see what's going on, you're going to look at that. And then the next one's other records and documents. So if you don't have the data, it's a new company, and there's not enough data to really see there, you might be able to use the Bureau of Labor Statistics, which is BLS comparisons, for other public data. So there might be some other information in the public domain that will certainly help. Cal OSHA is actually, and OSHA is a good resource. They have specific documentation of risks in construction, risks in, OSHA originally for meat packing was one of the big industries that we saw, where they actually had specific, that was one of the first ergonomic studies was done in the meat packing industry to help reduce injuries in that area. Flow charts and organizational charts. And what that'll do from mainly not so much an injury standpoint, will really help identify key personnel and need for succession planning. Is when you look at the organizational chart and you go, oh, this person has all the knowledge, and kind of our discussion, we talked about lab personnel before we started the call, is that, you know, if you have a biosafety officer or radiation safety officer for university environment, and you don't have an assistant biosafety officer, and that person leaves, or here's a good example for a biosafety officer. If you don't have, if you're a small program, you only have one biosafety officer, the biosafety officer leaves. Your grant, most of the grants, federal grants, are predicated on having a biosafety officer on staff. If you cannot recruit a biosafety officer, basically it's jeopardizing the research at that institution, that they may not be able to continue. So part of that is, well, can a biosafety officer from another campus maybe be able to serve in that capacity? Or can you have someone that serves as a generalist, and maybe they have enough knowledge that they can at least, you know, understand the biosafety officer role, so you get that succession planning, or maybe they start taking courses to become a biosafety officer, so we encourage that succession planning. So that's where the flow charts and organizational charts are really key to understand what are they doing, and if someone gets hit by the bus, what are we going to do about it? Or someone resigns or someone retires, we have those considerations. We need to identify concentration of employee operations and work performed. So that flow chart will also say, oh, we have all these people at this plant or all these people at this office, and we're not diversified in our locations. Well, if everyone's working, that's kind of it's an example. I wouldn't, but I think it's a good example. Is you look at 9/11. Most of the banking, insurance, Marsh, which is a large insurance broker, they were, had a lot of key staff in one of those buildings, and so they lost a lot of people. And so when you look at concentration of employees, of how do you, spreading out employees to the various locations, that may have different expertise. If they have specific expertise, it kind of helps identify that as well. Personal inspections, identify equipment and operations that could lead to an injury. The idea of managing by walking around, I think, is key aspect as part of that. We do have a quick question or hands up. Catherine, okay. So the question is, for ergonomics, is there a way to document the report and how the employee is following the recommendations? Once they have the report and they do not follow recommendations, how do you notate that? That's a good question. So I think on ergonomics, and actually this kind of came up situation today, is we use a product, Cardness, which is an online ergonomic program to help triage kind of employee discomfort. And so when someone gets hired on, they take this training that kind of goes through, walks them through how to do a risk assessment or how to do a self-assessment of their workstation, identify and ask them certain questions to identify if they're in discomfort. And based upon that, they get ranked to either high, medium, or low risk. Well, what we're finding in some cases is that some of the employees that have only been here for 10 days are high risk for discomfort, and it's because of their previous employer, which they've kind of come with some pre-existing injuries or some things like that. Well, one of the concerns is once you have a, from a work comp standpoint, they can file a work comp claim, but that information, if we can note it, now becomes, maybe it can be apportioned, or we have some documentation now. So that's actually a case we came up with today, is that we're looking at now documenting when we do an evaluation, if the person does indicate that, well, no, this was caused, they've been in pain from the previous employer, they do something that caused the injury, we want to make sure that we have that, because if they do become injured eventually, that can be part of it. Now, from, specifically to say, okay, they're not following the recommendations, that becomes a challenge, because some people, say, well, no, I feel more comfortable. And it's one of those things where, especially in ergonomics, it's one thing to say, okay, you need to wear safety gloves or eye protection. That's another thing to say, okay, I'm going to mandate that your desk height be exactly this high and your keyboard's this, because, they may say, well, it's, not the most comfortable for whatever reason. But But I think that it is worth notating. I mean, if you have software or other things that you want to say, you provide these recommendations or suggested a new chair, and that that the employee didn't want it or refused. If it does lead to something later, it may help demonstrate that it's a little bit more on the employee's fault. But you have to remember, at least from a work comp standpoint, it's a no-fault system. They can, as long as they didn't purposely, like cut themselves or they weren't horse playing, they're still going to receive compensation for their injuries if it's in the course and scope of employment. So the documentation will help, but it's not necessarily going to prevent a claim from occurring. So good question. All right. So personal inspections, as I kind of going back to that, identify equipment and operations that could lead to an injury. And again, by just kind of walking around, you see housekeeping issues, those type of things, or equipment that might be more dangerous, that can be part of it. The expertise within and beyond the organization, and that's, from interviewing employees, that's certainly one thing that can be done, is, or have consultants come in, but there might be key personnel. So if I'm a risk manager, I'm going to look to my EHS person or my radiation safety officer to tell me, what are the risks associated with maybe these new operations that we're considering. So risk treatment for work-related injuries. So now we're kind of going into, now we have identified, if you kind of look at it from the operations, we know we might have personnel risks, what they are, and then we say, okay, how do we identify them? That's through, inspections, through loss history, those type of things. And now we need to treat it. We need to determine, what are we going to do about it? So first of all, we can avoid it, not perform the work. We can contract it out or not do those type of operations because of that. And then the next three, we're going to go into a little more detail on loss prevention, loss reduction, and separation. Again, these are things we've said before in the previous chapters. It's the same. Risk treatments are going to be the same no matter what type of really the exposure that you're trying to treat.
Where would I was looking back on the smoking cessation effort for UC. Mm-hmm. Is that an avoidance because you're trying to get people to stop smoking, or is that more of the loss prevention because you're trying to decrease kind of the frequency? So
the question is, where would UC's smoking tobacco-free policy fit in? From an operational standpoint. Well, there's actually a couple. One is, being the leader, especially for having medical centers, it's more leading by example. It's to be able, from a reputation standpoint, we should be the epitome of promoting health and well-being. So that's kind of the first kind of premise that was done around. There's obviously the wellness aspect of we want healthy employees to be more productive. This wasn't part of it, but if you think about it, typically smokers take more breaks. So you could, someone could make the argument of, and actually, there was actually an article that was sent the other day that someone talked about, the productivity loss of smoking, and I'll have to find that and send it out. But that could be, someone could say, okay, the claim of we're losing productivity, that wasn't the reason why UC did it though. But I would say it was generally more on the wellness, and it was really considered to be the right thing to do. We should be promoting healthy behaviors. Especially when we're doing research and it shows that it's not healthy to do. The other thing that's kind of it's UCLA was one of the first campuses that went smoking tobacco free. They actually did it on Earth Day, and one of the reasons why they did it was that the most littered item are cigarette butts, and that if you look at all the problems that the cigarettes butts cause. So it's actually sustainability. It's actually, so they did it on Earth Day as a sustainability issue of, because people basically litter, and also the idea of clean air. So so UC Riverside's using the theme of clearing the air. UCLA, I think, theme is breathe free. So they're all kind of using these themes that are centered around that aspect of it. But I generally say it's more of a health. It is more of a health and wellness aspect. And then if you figure that if someone's, a regular smoker, if they have cancer, well, that becomes you may lose the employee not because of work-related, but because of an illness that was, because of cancer, or emphysema, they may not be able to perform the work. So I think from that capacity, you can say, okay, the good health of the population, that can also be part of the human resource potential there. So we look at loss prevention. We're going to talk about a couple different things here. Now, this whole section's about 3 or 4 pages, and I'm going to go through these fairly quickly. And this is where, again, where the challenge is when we talk about kind of safety engineering, or what people may consider to be common sense when we start thinking about some of these. So from a loss prevention standpoint, we're really looking at 2 specific aspects. There's safety engineering and there's workplace design. And safety engineering is considered really the physical controls and the procedural controls that we may put into place. So those physical controls, putting guarding on, on machinery, or it could even be putting guardrails on an elevated location. That would be a safety engineer. If you think about engineering, it's usually going to be a physical, at least in this case, when we talk about physical controls, they will be physical controls of kind of preventing that aspect. So guarding, ventilation, make sure we have good air quality, housekeeping, not having stuff on the floor, preventing slip and falls. So the physical controls really can be safety interlocks, all those type of things that would go with it. Procedural controls, we're going to be looking at, actually I'm going to go back to the one, because I think it even talks about wet methods, and I'll just kind of go through some of these fairly quickly before we get there. So yeah, for safety engineering, I'll go through some of the other loss prevention physical controls. So material substitution. So this is on page 8.14 of the book. But I would take a look at these on here, but again, most of them you'll find are probably common sense. Isolation. Isolation is used to separate employees and others from hazardous materials or processes. Wet methods, introducing moisture to production to keep dust out of the environment. And so if you think about if anyone's ever cut ceramic tile or blade tile, there's a specific type of saw. Well, there's water with it, so that way it reduces the dust and other things. Talk about guarding, ventilation, maintenance, proper maintenance, prevent breakdowns, housekeeping, prevent slip, trips, and falls, and then personal protective equipment would be another safety engineering, which includes devices or garments worn to protect workers from injury and all this. So gloves, goggles, lab coats, overalls, those type of things might be considered more of a physical control. On the procedural controls, education and training is considered to be a procedural control. Now, I don't want to go too much in the CSP or hierarchy of controls, but essentially the idea is you want to, if you can, eliminate the hazard. First you want to eliminate. If you can't do that, you want to substitute a material that's less caustic. If you can't do that, then you engineer out the hazard. And then the next step after engineering, you're going to look at would most likely be education, and then PPE. And so the lesser effective methods are really the training aspect on PPE, because you want to try to, because it brings in the human behavior element that people can still bypass things. And so if you can eliminate the hazard just by people not having to be exposed to it, that's really the best option from a risk control standpoint. But again, that may not always be possible. Standard operating procedures, or SOPs, will describe step-by-step how to perform a task to avoid injury. Job rotation. So one of the things that Rayleigh's or Bel Air had done, if you go into some of the newer stores, you'll notice half the check stands face one way, half face the other way. The idea is that people, from an ergonomic standpoint, when people, and this is more of an administrative control, that they might, they're going to be checking. If they're doing that all day long one way, they're using that the wrist, they're twisting the wrist. Well, so when I was with Rayleigh's, we actually helped divide. We said, we're going to have the check stands from a design standpoint, half face one way, half face the other way. So half the shift, they go the other direction. So they're using different body parts, different muscles, so they're less likely to get cumulative trauma type of injuries. So that's an example of how you might put some procedural controls. And just, and why it's a procedural control and not necessarily designed per se is that you can have those things, and if you just keep people in the same check stand, they're still doing the same. You haven't done anything. So that's why it's a procedural control. Is you have to have management, actually do the rotation as part of it. Medical controls, which would be medical examinations, things like that, and then as well as proper supervision, which I think is really key as well, that people are supervised. When we look at workplace design, which many times we'll kind of really consider ergonomics is really what we're talking about. And even when they talk about human factors engineering and biomechanics, I would argue that's really all ergonomics, at least from my standpoint. So ergonomics and manual material handling, how can we reduce the amount of lifting? Well, forklifts, dollies, things like that. We're dealing with cumulative trauma disorders. How do we prevent people from overusing certain body parts? The physical layout of workstations, well, that's an example I gave with the check stands in a grocery store. But you can think of a layout of a computer workstation that someone works out. Displays and controls. So from workplace design, this part may not be so much ergonomics, but if you think about it, there's certain pieces of equipment, in order to operate it, you have to use both hands pushing a button. Well, the reason why they do that is so if you only had one button, there's a possibility you might want to put your hand in the machinery as you're pushing it in. So it's a way to make sure that you don't stick body parts where they shouldn't be going. You also notice that controls are certain color-coded, so people don't press the wrong buttons. That actually has something to do with ergonomics, is the displays and controls. Are they easy to read? If you think about car design, where are the displays? We're seeing more displays now. They're almost like heads up. They're actually on the dashboard. That's part of the ergonomic design aspect. Fatigue is something that needs to be addressed, and then as well as ergonomics really plays a role with Americans with Disability Act as well. On the human factors engineering, that's really the process that applies knowledge of human behavior to design equipment used on and off the job. And so this is where I would say human factors engineering, that's actually button placement. If you think about the car that when you drive, again, applies knowledge of human behavior to design equipment. Where the shifter is, where the turn signal is, the location of the devices. So now we think of, okay, human behavior. Now we know that when people reach over to change the channel on that becomes, they might get in an accident. Well, now that you have controls on the steering wheel, or they're voice activated. So these are all kind of engineering controls, or human factors engineering. And then biomechanics is the process that views people at work as special kinds of machines functioning with environments filled with other machines. And that's really just how do people interact with the various machinery and the processes that are part of that. So now we'll move into, so we were on loss prevention, now we're loss reduction. So loss prevention is the idea that we don't want injuries to occur in the very first place. We're going to prevent them from even happening. But now loss reduction is, some injury happened, and so the reality is that it's really what I call post-injury management. They call it rehabilitation in the book. So, but post-injury management, so when prevention fails, the goal is to reduce losses by restoring the health and productivity of those temporarily disabled. Actually, go over time here. From injury and loss, rehabilitation management is an effective loss reduction measure because it reduces the severity of disability or employee income losses. So again, it also helps the employee income losses by doing it. You also have to keep in mind that it'll also help, if you have return to work programs, this is all part of the rehabilitation program. What I always point out is, it helps avoid litigation when you have people back at work. What kind of commercials are on TV in the middle of the day? 1-800 sue your boss. There's a reason why they're on the middle of the day, because they know people that are injured are typically at home watching people sport. And so it's eventually they'll, the way these things are worded is it wasn't your fault, it's the employer's fault. Eventually they're going to call. So keeping in contact with the employee is really key, and we'll talk a little more about that in a second. So providing quality medical care, ensuring prompt return to work, and providing voc rehab is key to that. Post-injury management, the three types we're looking at: physical rehabilitation, which restores motor skills impaired by injury illness; psychological rehabilitation, which is the healthy mental condition, and which would be more towards, especially from a workplace violence issue, things like that; and vocational rehabilitation, or voc rehab, enables a person to return to previous work tasks and other activities. In vocational rehabilitation, the main goal is to get people back to performing work, typically. When we look at variables that influence rehabilitation potential, the type, the characteristic of the impairment, functional limitations, what can they do, the capacity, and the prognosis of what the person, what people, what does the doctor say? What they're going to be able to walk, they're going to be able to use their hand. That will also have an influence on rehabilitation potential. Perception of the situation by the disabled person, and then also environmental conditions of what the support of the family network. There can be more stresses at home now because the person can't work. The other relationships that influence rehabilitation potential, and this is, I think, really important. The very first one is employer and injured employee relationship. Is just because the employee is injured, a lot of times they never get a call. And if you consider that most people, most of their working lives, hours are spent at work, even more so in some cases than with their family, the employer really is part of the family. And so and it's part of who they are. So if someone gets injured and they never get a call from the boss, there's that disconnect. At some point, they're more likely to call that attorney. And so when I was with Raley's, we used to have care calls. And it was a requirement that every 2 weeks, or actually every week, the store director actually had to call injured employees, and it's to help with that connection so they didn't feel that they're away. Because once you lose that connection, it's hard to get people back. Physician-patient, obviously, claimant and insurer, injured employee and family, disabled person and rehab specialist, and injured employee and attorney. So those are the different relationships that may have. Obviously, the injured employee attorney is going to, it's the complete opposite relationship of the employer and the injured employee, really trying to turn one against the other in many ways. First response to injury is the most important, which is need to provide immediate medical attention. Hopefully there's a designated medical facility to manage care as allowed by law. What I mean by that is that in California, the employer controls medical care for the first 30 days. It may be different in other states, but there's also other laws that allow for complete management of medical care. Determination made of the medical only claim or lost time incident. What the issue here is if it's what we call the 3-day rule. Once someone's off work for more than 3 days in California, it now becomes an indemnity claim, and now they're entitled to basically the compensation of benefit replacement or wage replacement as part of that. If they're only injured for 2 days, only the medical costs are reimbursed as part of that. And it also takes longer to close out what's considered to be an indemnity claim. And it's really key to document injury and circumstances, which is really the accident investigation. It's really the first line of defense in controlling the rehab process because you might be able to determine other physical problems that weren't related to injury that now they're claiming as part of that problem or injury. Post-injury management also, circumstances that limit effectiveness of rehab program and must be managed. So extended hospitalization, uncoordinated medical treatment, extensive medication, lack of clear diagnosis. All these things on this list, for the most part in California, we have what we call nurse case management. And the idea of nurse case management is the idea to address this, is that they're going to be managing the claim, working with the physician, and making sure that the person, as far as the type of treatment, conservative care, if the doctor immediately wants to go to surgery, they're going to double check to make sure that all these other elements have been taken care of before we go to the surgery option. And again, just really trying to make sure that there's a plan of action when it comes to the rehabilitation plan. Because otherwise, if it was just left up with no one monitoring, then that's not going to happen. The other aspects that we have after loss prevention is separation and duplication. And separation involves arranging activities and resources so that no single event can cause simultaneous losses to all of them, such as when an organization prohibits key personnel from traveling together. And again, Raley's had a policy. A lot of large organizations have a policy that the CEO, COO cannot be traveling on the same plane together. Duplication involves creating backups to be used only if the primary activity or asset suffers a loss. And this is where cross-training would come in and training other employees. So if you lose someone, you have another person. So if someone's hit by the bus, you can have someone that can certainly step in. Now, for risk treatment for work-related violence, workplace violence is often thought to occur only between coworkers, but I think, as we know, can be a customer, or someone has a personal relationship with an employer, or a complete stranger. The risk control measures, when we look at them, really the first part is hiring process. It's one of the most effective methods in preventing workplace violence is comprehensive screening of potential employees, making sure they're compatible to work there. Make sure the supervisors are trained in recognizing, avoiding, and reporting potential violence. Having written policies in place that indicate, the types of conduct, what's acceptable. Procedural safeguards, employee procedures, measures in place to ensure they are followed by all employees, and then also a termination process. So that when you do terminate, they get escorted out the building, return of security badges, meeting, so kind of get the demeanor of how are they handling it, because in many cases you might find that okay, the person's going to come back, and it's more of like a behavioral threat assessment in some ways. Representative risk control measures against violent attack. So if you kind of think of this, where are these type of tools, where they install alarms, intercoms, cameras. Okay, what's the most likely place that's going to have workplace violence? It's a bank, because of armed robbery, those type of things. So they provide every one of these things, walls, locks, install alarms, intercom systems, telephones, use cameras linked to monitors. There might be guard stations, equip vulnerable personnel with appropriate personal protective devices, or panic buttons, those type of things. So those are all kind of, so depending on the circumstance, these are common risk control measures, and so this is something that you'll probably have a question on of what would be an appropriate risk control measure for this. If I remember correctly, there's a couple questions really on kind of kidnap and ransom and those type of things. On the procedural side, this talks about trained personnel and self-defense measures, encourage personnel to avoid statements or conduct that might invite attack, conduct a weapon search on all persons entering the premises. So these are, again, just some of the things you can use. And then finally, special managerial risk control efforts. Things that might be going on in the community. So, for example, we got an email this afternoon that the Occupy protest will be here this weekend. So we advise personnel that if you don't have to be in the area, you may not want to come. If you plan on going to work over the weekend, just be advised that this is going on. So as an employer, we make sure that we know what's going on, and we have a relationship with the police department to keep us notified, so we can notify our employees. So that is also part of the workplace aspect. On kidnap and ransom, actually I know I'm going long here for tonight, but I have to get the other glitches there. So kidnap and ransom, the most effective way to control kidnapping and ransom loss is to prevent it. Obviously, you don't want to have that even happen. Prevention may mean not doing business in a dangerous location. So the idea is if you identify a location that's hazardous, do you really want to have people there because they're more, there's certain locations where they know they're going to get high potential for kidnap and ransom. Organizations that must operate high-risk areas should employ various protection measures, which might include, again, maintain low profile, no logos on vehicles, clothing, or not going to major events, employing bodyguards, housing employees in walled or secure compounds, using armored vehicles, train employees to recognize potential kidnap situations. So that part of that might be varying the routine, do something different. If they have the same routine in certain locations, they'll know where to stop them at that one intersection. So do something different in the way they get to work. And then the risk manager should be alert to changes in the political and economic environment that might change the organization's exposure to kidnapping, or just in workplace threats in general. So as a university, we have a monitoring service that basically tells us what's going on around the world, where we might have students and researchers there. And so when we do hear of events, we try to extract them, and that's basically what we did in Egypt not too long ago. Kidnap and ransom, if payment is deemed appropriate, arrangements have to be made with the organization's bankers and other source of funds. Make sure the payments are marked. Except for cases of politically motivated kidnapping, most kidnapping involve ransom demands. And then most people don't, but companies with kidnap and ransom loss exposure generally purchase kidnap, ransom, and extortion insurance. When I was with Raley's, the owners, the Teals, we had K&R coverage for them as well and their family members. So in the event that someone was, or the family member was kidnapped and ransomed, that essentially there would be, it provides expertise and to basically handle the situation, whether it be monetary and things like that. I think there's a movie that was out a while back that was about, he was a K&R specialist, and I can't remember the specific movie now, but kind of goes into that. So, and the final couple things here, assessing, this is kind of our case study. So we'll go through a couple examples here. So Hightower Incorporated is a publicly traded corporation with 500 employees, produces a line of sophisticated handheld electronic devices that combine features of smartphones, e-readers, and company's proprietary social network interface. These items were conceived by Hightower's founder and chief executive officer, Sophia, whose media-driven image as a self-made technology visionary is the focus of Hightower's successful marketing strategy. If you want to say they're copying Apple example and just changing a couple things, that's kind of what you can kind of see here. So if you can imagine Apple being part of this. A little bit more information. I'm not going to, let's go to the key points. Hightower's corporate headquarters are in California, where it houses the majority of the senior management and human resources, marketing, research. They also have a facility, manufacturing facility in a developing country where taxation and labor laws allow for cost-effective production. But the facility is in the region's largest and prominent employer, has a distinctive logo featured on its buildings, vehicles, employee uniforms, and there's an executive there that oversees the operations. As a new risk manager, you need to assess the risk, answer the following, what's the possible threats to Hightower's success, what methods might be used to treat the risks, and so on. So, case analysis to assess Hightower's human resource risk. This is what a risk manager would do. And this is really what we do. You want to look at, all the things we talked about: health and education of the population, proper personnel selection, preservation of employees. So these are for the first part. As a manager, to help us to do that, we're going to look at, risk assessment questionnaires, loss histories, other records, documents, flow charts. So literally, we do. I've used this current practice. So depending on what the operations are, you look at those documents, and we're now looking specifically for human resource risk. The risk manager would also consider prevalent personnel cause of loss. So what's the exposures? There might be work-related injuries, retirement, resignation, work-related violence. So I'm going to consider that as part of when I do that analysis. And then after ascertaining Hightower's human resource risk exposure, manager can choose from a variety of techniques. So we'll look at avoidance, loss prevention, loss reduction, separation, and duplication. So those are the tools in our toolbox that we're going to use to address these different things. So more specifically now, risk manager, I look at the organizational charts, and identify key personnel, look at job descriptions, and basically the organizational chart reveals that Sophia is relied on to generate ideas for the company's signature cutting-edge products. Speak to you, jobs. Yep, there we go. Additionally, she is viewed by the industry and the media as the embodiment of Hightower's corporate culture and as its lone spokesperson. Okay. So action, review the risk manager's assessment of the organizational charts. So without looking at the feedback, look at Steve Jobs, or if you look at Sophia in this case, role at Hightower, presents potential human resource risk exposure. If she was suddenly unavailable, maybe it's a medical. So that's the other thing that wasn't listed in here. But I know with Bickmore, all the executives had to have an annual physical. So it's not uncommon for members of the they want to make sure, are they healthy to continue? They want to know what those risks are if they can't perform their job, so they can make succession planning. So that might be part of it as well. So when we talk about suddenly unavailable, it could be also for health reasons, which Steve Jobs is a good example why he was out. Hightower's reliance on her product ideas and media presence could constitute a serious liability, as the company could have difficulty achieving its fundamental goals in her absence. So part of what they would do is then look at succession, making sure there's other people that can step in. When I look in the organizational chart, notice that Hightower's corporate headquarters in California as the sole location, and the majority of its senior management and human resource marketing. Well, if they, when they say California, they should just say Bay Area, and you say, okay, earthquake risk, okay? What's the, if we had an earthquake and then we lost all those personnel, so that what they're saying is corporate headquarters reveals a potential human resource risk exposure. A single event could cause losses that cripple Hightower's management and strategic functions. So that's, again, you look at it, say, okay, we have all these people here, maybe we want to be in Sacramento. There's just only wildfire exposure there instead of earthquake exposure. So those are the things you keep in mind as you go through this. Risk manager next considers Hightower's manufacturing facility. Okay, so we know this facility is in a developing country. So one of the concerns we, or actually this is, I'm sorry. The first part talks about back injuries. Your corresponding review indicates a disproportionate number of back injuries. So if we know that, We're going to look at ergonomics. How can we deal with material handling? What's the causes of those back injuries? And so we want to help prevent some of those. So this one deals with the risk manager, the facility's location, economic climate. I was jumping ahead here. So if we know that the person, one of the key executives, we might consider, removing logos from some of the buildings. Try to make it less, provide, some other things so it's lower profile. So it talks about facilities high profile, otherwise depressed region, presents the possibility the executive in charge of the operation could be a kidnapping target. So how we deal with that, make sure they're in a compound or other areas that they're protected. So again, all the things we kind of talked about. One thing I don't necessarily like in these examples, they kind of say you might want to consider, but they don't say here's the things you may want to specifically look at. The risk manager identifies other potential human resource loss exposure, but believes that these are the most potentially serious. So the big ones are founder and CEO Sophia's role, concentration of managers and executives in a single building, back injuries, and possibility of kidnapping. So actually did identify. Now we're going to come up with the recommended treatments. So, what the idea is, what would the organization do if Sophia suddenly were not available? If Sophia were unavailable, could the organization achieve its fundamental goals? So the question is, which one of these risk treatment options is most appropriate for human resource loss exposure posed by Sophia's role at Hightower? Well, avoidance is not the answer, and this is the type of question you'll probably see. Well, separation, well, I don't know how you're going to do that. That's probably going to be, actually, yeah, there it goes, okay. So in this case, it's going to be duplication, which is a risk control technique, uses backups or spares. So the idea is we want to have cross-train. We want to have someone else that's going to have her capabilities. So you might kind of, if you look at the question when you have this on the exam, you go, okay, you're going to, if anything, do a process of elimination. Well, loss prevention probably wouldn't help with that, but duplication, meaning we have someone else that can hopefully step in, and then maybe share the limelight a little bit with her. Okay. So in this next question, risk manager considers loss exposure posed by Hightower's corporate headquarters in California. Okay. So which one of these risk treatment options is the most appropriate for the human resource loss exposure posed by Hightower's corporate headquarters? So the idea is, if the building goes and everyone's lost. Well, avoidance, no, that's not going to work. Duplication, we can have another building, but we can't really duplicate those people. So separation of having people at different locations, separating those activities would probably be the most appropriate measure. Back injuries. So describe risk treatment strategy. Activity, this is looking at ergonomic type potential design, design jobs to fit employees' capabilities, consider making computer and other workstation elements as adjustable as possible. So again, it's really going to the biomechanics engineering aspect of there. And then finally, Hightower's risk manager addresses the possibility of the kidnapping of the executive in charge of the manufacturing facility. Although loss frequency is low, loss severity can be high. Risk manager considers that duplication resembling the technique used to treat loss exposures with a CEO may be an effective strategy for ensuring that some manufacturing facilities executives' responsibilities could be fulfilled in the case of kidnapping. However, the risk manager must also address areas that could contribute to kidnap prevention. So in this technique, the idea is, well, we can have someone else that's familiar with the facility just in case as a backup if that person did get kidnapped, we can still continue to operate. But we'd still need to address the kidnap exposure specifically. And so the strategy would be attempt to lower its profile in the area by removing company logos and other indications of company ownership. Hightower can implement additional measures such as employee bodyguards, housing employees in walled or secure compounds, or using armored vehicles for transport. So it kind of gives you, if nothing else, an example of really the steps by doing the case study of how you would approach the situation. And it's really going to be similar no matter whether it's human resource risk or general liability risk or other risks of how you would want to move forward. So with that, I want to thank everyone for sticking with me tonight, and we'll look forward next week. We have Chapter 9, and